Hello, this is Tom O'Connor. Welcome to the University of Florida e-Discovery Project Story Booth. We're here live at the e-Discovery Conference going on at the Levin College of Law at the University of Florida. And I'm here now with Suzanne Clark. Welcome.
Thank you.
Suzanne is, correct me if I get any of this wrong, you're a litigator in Jacksonville.
Yes.
With?
Jimerson and Cobb.
I'm using paper here, so we keep that below the camera so that nobody sees that in e-Discovery. Jimerson and Cobb.
Yes.
And you're also very active, as I recall, in the ACEDS chapter in Jacksonville, which is perhaps the most active chapter of ACEDS.
I think all the chapters are getting more and more active, but yes,
Okay,
we like
good.
to think that we're very active chapter.
We'll talk about that in a second then.
Yes.
But first let me ask you, as someone who's active in this community, who's here for this conference, what's your sense, what's your worldview of where we are in e-discovery now? Where is this profession? What's it all about, Alfie?
Okay, I have a couple of perspectives.
Okay.
I have a perspective from my litigation practice at my firm, which is a small firm. We have 10 attorneys,
Okay.
4 partners, 6 associates, and then I have my perspective within the community, the global e-discovery world, where I'm interacting with other e-discovery professionals in my extracurricular, more academic life of expanding myself as a professional. So I'll talk about those in 2 ways.
Okay.
So within my litigation practice, like I said, we're a small firm. We deal with business litigation. We have a lot of small to medium-sized businesses, and we deal with business disputes, and so I'm not dealing with a lot of big data. But what I have noticed a lot is social media and mobile device evidence is getting to be very important in my practice. I think it started with family law and personal injury law, but now it is becoming important to any type of litigation, and you don't have to be a large corporation to create a lot of data, especially in the area of mobile devices and social media. So I just got a call today from my office from one of the other associate attorneys who had a situation where his client is being defamed on Facebook, and he wants to be able to collect that in real time, to have that to decide later what you're going to do with it. So he wanted to talk to me about what are our options there. And in the past, he might have thought a screenshot or a print to PDF would have been good enough, but now he says, I want to come to you so we can talk about what's available out there in the software world, on the internet, service providers that can help us collect this data defensively, that have the software so that we can outsource that collection. Things like that, then not only are you going to have defensible collection of electronic evidence, because what I like to say is, the evidence is electronic, it's created electronically, so you want to also be able to produce it and preserve it electronically,
right,
and not change the form of production. So things like that, form of production, proportionality. In small cases, if the producing party is going to have to pay $1,000 to grab a mobile device, is that really proportional for a $16,000 case? Something like that. So that's what I'm seeing in my practice.
So I'm sorry, but let me interject a quick question. Along those lines, have you had any authentication issues yet regarding introducing something from social media as evidence? That's the up-and-coming legal issue.
Right. Authentication, that is it. You know what it depends on? This is what I say. It depends on the sophistication of your opposing counsel. So if they are in their own practice producing print screens, and then you go produce a print screen, they just accept it. So it's going to depend on their education. Are they going to the University of Florida e-Discovery Conference and finding out that's not good enough? And
Right.
so you need to get ahead of that before they get word that a print screen is not good enough, and then they can give you grief about it later.
Showing once again the incredible amount of one-upsmanship that goes on in the litigation world.
Yes,
Right?
yes, absolutely.
Good. No, I'm sorry, I interrupted you. You were going to make a second point
Right,
about the
so-
state of e-discovery in general.
So it's interesting because when I am surrounding myself with other ACEDS professionals, it's just a whole different world, and we're talking about much bigger ideas, and so I know that there's probably other people at this conference that are dealing with big data that can tell you more about what's going on there, but just proportionality not only in production, but also in preservation. I know that's big. Going in, if you're in federal court, and getting an agreed preservation order That's a new idea and a new concept that I've been hearing about, so that you can go ahead and decide ahead of time, we're going to be able to just preserve this, and this isn't going to be as important, and we're
Right.
going to look at proportionality factors in deciding preservation, not just production, not just the other elements of the EDRM.
Okay. So let me shift focus just slightly. You've mentioned, and I brought it up originally, but ACEDS. How important is ACEDS certification? Mary Mack, of course, the director of ACEDS, is here and
Yes.
will be one of our interviewees later in the day. But from your perspective as a practitioner, how important is that certification, especially when dealing with the court and credibility?
Well, I think it's, I am a big proponent of the SEDS certification. It has made an enormous difference in my career. I have had other e-discovery professionals say to me, you have credibility with me because you have the certification. I'm not going to need you to further prove that.
Right.
So if I am looking for opportunities to bring work into the firm, things like that, it helps a lot. It's an academic training.
Right.
So what it did for me is, as a litigator, I was versed in the law, but I was not versed very well in technology. So it helped studying for that exam and finding questions as I studied and asking colleagues that were other members of ACEDS about technical areas really helped me. And then now I feel like I can translate and I can take what I know and build in the technology. So it's just invaluable. On the other hand, if someone's in IT, that ACEDS training is going to teach them the legal aspects and what's relevant in the legal realm to e-discovery, and then they're going to be able to talk to me and understand what's important to me as a litigator. So it's a way to bring those two groups together and have them have professionals who can translate between IT and legal. And IT, they really want attorneys who can understand what they do. You don't need to be able to go in and deal with the computer. You need to be able to instruct IT based on our legal situation. This is what we need you to do in your job.
Right. Right.
So.
Last question.
All right.
This is not one we discussed earlier, so if you need to take a second to think this over. If you could have one e-discovery superpower, what would it be?
Oh my goodness. I think that I would be able to, just like in the Matrix, upload a computer science degree to my brain. So
Upload
and
capability. And fly.
Yes.
Fly's like that just kind of goes without saying, right?
Right.
Flying's just, yeah,
Superpowers.
That's part of the deal.
Yes.
Yeah. Great. Suzanne, thanks so much. Always a pleasure
you.
talking
Thank
to
you,
you.
Tom.
Thanks for taking the time, and
Okay.
we'll see you folks again later on today from the University of Florida e-discovery project.
Conference.
No, I always forget the last. I had to write it down. The story booth.
The story booth.
booth.
Go Gators.
Thank you.